Good afternoon. Again, it's still Friday, March 13th. Senate Finance Committee is going to begin voting. We're going to start with voting list number 10, your yellow list. The first bill on the list is with Lisa. It's Senator Kramer's Senate Bill 445.
Senate Bill 445 requires the governmental unit that employs firefighters to pay overtime wages for each hour over 168 hours that a firefighter works during a 28-day work period. A county or municipality must provide a firefighter at the time of hiring and at the time of any change of the firefighter's rate of pay, notice of the firefighter's rate of pay, the regular pay periods, and the firefighter's overtime rates of pay. And for each pay period, provide a statement of hours worked, gross earnings, and deductions. The bill specifies the grievance process if a county or municipality fails to pay wages due or provide the required information, and specified circumstances of firefighters entitled to wages and damages. There's one amendment, and the amendment extends the effective date of the act to October 1st, 2028.
Move favorable as amended, Madam Chair.
Thank you, Senator Kramer. Who seconded it? Senator Lamb. All in favor of Senate Bill 445?
No, thank you, Madam Chair. I'm going to vote for this bill, but it has been brought to my attention that this is an increase of $6 million annually to the city of Baltimore. And I just hope that we could, in understanding that the state would see in its heart in future budgets to understand the fiscal burden that it may place on the city and the chance that it may ripple down and cause the possible closing of other fire stations or whatever. But I'm going to vote for the bill because it's an important bill, and Baltimore City is an outlier in this case. But it is a significant burden to the city that may result in the closing of some possible fire stations. So thank you, Madam Chair.
Senator, I actually have a question. Is that $6 million after they consider the overtime that they're paying now, or are we deducting the cost of overtime?
No, once they lower the threshold, the overtime would increase dramatically. Especially in a city like Baltimore, oftentimes we don't have enough EMSs available. The firefighters are typically the first responders, so they're doing a great bulk of the work. There's maybe not as many fires, but they're doing an awful lot of heavy lifting, and so this will increase the overtime and other things dramatically.
Is there a chance that they may hire some more firefighters so that they aren't paying overtime? I guess that's really my question.
Oh, I got you. So I think they've been really actively trying to recruit. But being a firefighter in Baltimore is not an easy job. So, but I think the department is trying to do as best as they can. We have one of the best firefighters, bar none, but it's a tough job.
Thank you. Do we need to call the roll, or?
Nope.
All in favor? Oh, we need to call the roll. Tammy, please.
Senate Bill 445, favorable with amendment. Vice Chair Hayes.
Yeah.
Yes. Senator Kramer.
Yes.
Yes. Senator Reedy.
I'm voting no only because I think this supposed to.
I'm concerned about collective bargaining agreements locally. I think it's something that should be collectively bargained locally. Carroll County already does it, 42 hours. Frederick County doesn't. So that my vote is, I'm sympathetic to the argument. My vote is no on this one.
Senator Mounts. No. Senator Jackson. Yes. Senator Washington. Pass. Senator Guile.
Yes.
Yes. Senator Lamb. Yes. Senator Hershey. No. Senator Washington. Yes. Madam Chair.
Yes.
Yes. 7-3. Bill passes.
Thank you. Lisa?
The next bill is Senate Bill 656. It specifies that, in addition to existing civil and criminal penalties, a person who violates the prohibition on knowingly manufacturing, selling, delivering, holding, or offering for sale in the state a cosmetic product that contains one of any of the 24 listed intentionally added ingredients is liable for civil damages sustained by the individual and reasonable attorney's fees. The Maryland Department of Health may investigate any complaint alleging that a person has violated the prohibition and may enter and inspect the premises of the person to determine compliance. There's two amendments. Amendment 1 is technical, and for Amendment 2, you should have a reprint from yesterday, if it's still there. And so on page 2 of the reprint, Amendment 2 makes the violation of Section 21-259.2 of the Health General article, which is the section that lists all of those additives and unfair, abusive, or deceptive trade practice. On page 4 of the reprint, the amendment specifies that an individual needs to have suffered actual harm as a result of the violation in order to bring a civil action under the act. The amendment establishes a 3-year statute of limitations for any actions and specifies that a prevailing plaintiff may be entitled to treble damages and punitive damages in addition to reasonable attorney's fees. And finally, the amendment creates the Harmful Hair Restitution Fund to support research and treatment of conditions caused by harmful hair chemicals. And funds resulting from the enforcement of this act, other than funds recovered in a private right of action, shall be credited to the fund. And a person who suffers actual harm as a result of a violation and files a complaint with the Attorney General may be eligible for a grant under the fund.
Do I have a motion on Senate Bill 656? Thank you. We have Senator Guile and seconded by Senator Lamb. I guess we should call the roll. Okay, no, go ahead.
Yeah, thank you. First of all, I was trying to, what is considered the premise for this?
What do you mean, the premise?
I mean, it says that there can be, the inspectors can enter the premise to look at it. So are these just in?
Like the store that's selling the products, or if there's a salon that's using them?
Okay, so it's not individual households, or could it be someone's households that they provide?
I wouldn't think so, because they're not offering for sale or manufacturing it in their house.
Okay, and then with respect to, we talked about private right of action, you said it requires actual harm. Is that something that we normally quantify or clarify in private right of actions?
I mean, you can, I guess, if it would be strict liability, then it would mean any violation of it, regardless of whether the person suffered harm or not, they could sue for, but this would require them. I mean, it depends on the statute whether harm's required or not.
Okay, and then finally, you state that it creates this new harmful hair chemical restitution fund. But I wasn't sure how that was funded.
So if the Attorney General has some authority, since this would be an unfair and deceptive trade practice, so people could file a complaint with the Attorney General, and if the AG recovered any money as a result of a violation, that would be credited to the fund. But if someone brought a private right of action and they recovered on their own, that's not part of the fund, that's their own money to keep.
So if you file on your own and you go through the lawsuit and there's damages, then you get to keep them. But if you call the AG's office and say, I think that there has been a violation, you first have to prove that you had actual harm, right? That's what we changed?
For the private right of action, well, under the bill as amended, both the private right of action and to get money from the fund, you would need actual harm. But I'm guessing that would be part of the Attorney General's investigation, is determining whether you suffered harm from that. I mean, the administrative process would be a little less burdensome because you wouldn't have to go get your own attorney and put some of your own skin in the game, I guess.
Right. All right. Seems a little complicated, but thank you very much.
The fund, wasn't part of the hearing. What is the fund, and how does the fund get funded?
So these were amendments requested by the sponsor, and so that was added on after the hearing. And the fund is established, so any money that the state recovers from the violation, if the state is enforcing with their authority, then that money would be credited to the fund, and anyone who was injured as a result of these products and filed a report with the AG could then apply for a grant from it.
Okay, I remember being here for part of the hearing, and then I had to go to a bill hearing. Was the report in the hearing of lots of this kind of thing happening? Has this been I wouldn't know, but has this been like something that's been happening a lot? Is there like lawsuits that? Is it something where there was harmful chemicals being sold for a long, long time, and now they're not, but they're still on shelves, or like what was the impetus for the bill?
Yeah, I think the fact that the chemicals were banned, there's still a lot of products being sold in the state or manufactured that are using them, even though they are illegal. So they were hoping that by adding the private right of action, that would give a little more enforcement to, or like, I guess, put a little more, the manufacturers and sellers would be subject to more penalties and hopefully be more likely to comply with the law.
Okay. Okay. All right.
It's been a law for a while, 2 years.
Yeah.
Any other questions? Okay. I think we probably need to call the roll.
Senate Bill 656, favorable with amendment. Vice Chair Hayes?
Yes.
Yes. Senator Kramer?
Yes.
Yes. Senator Reedy?
I'm gonna say no.
No. Senator Jackson? Yes. Senator Washington? Yes. Senator Guile? Yes. Senator Lamb? Yes. Senator Hershey? No. Madam Chair?
Yes.
Yes. 7-2, the bill passes.
Okay, thank you. Senate Bill 703, Lisa?
Senate Bill 703 repeals the requirement that a dog owner in Caroline County must apply to the county tax collector for a dog license each year. The bill also repeals other related provisions related to dog licensing in the county, but retains the authority of county commissioners to adopt rules and regulations regarding the issuance of dog licenses in the county. There are no amendments, no fiscal impact, and no opposition at the committee hearing.
Do I have a motion for the Carroll County Regulation of Animals? Senator Lamb, do I have a second?
Second.
All in favor of, all in favor of Senate Bill 703? Is this a unanimous? Okay, unanimous vote. Okay. 786.
Okay. Senate Bill 786 exempts a transportation network company that contracts with the Maryland Transit Administration to facilitate the provision of transit services to persons with disabilities through transportation network operators from the general requirement that individuals who provide transit services to persons with disabilities receive a state and national criminal history records check, and instead requires the contracting transportation network company to conduct an annual background screening of each transportation network operator that provides transit services to persons with disabilities. The background screening must meet specified requirements in existing provisions of the Public Utilities article that require national criminal history records check and a driving record check as a condition of licensure. There are two amendments. Amendment 1 is technical, and Amendment 2 requires a transportation network company to provide information and training on laws regarding non-discrimination and accessibility to transportation network operators providing services under the Act, and requires the operators to follow certain procedures when providing transportation to a person using a mobility device. Those amendments were requested by the National Federation for the Blind, and we worked with them with Uber, who is also okay with those amendments.
Do I have a motion on Senate Bill 786? Senator Mouch, you have a question or comment?
Yeah, real quick, Madam Chair. I just want to bring to the attention of the committee, something about this bill was brought to my attention after the hearing. Well, one thing is that there's a company that does this business that also has a direct link to my district that I wasn't aware of. I totally understand and appreciate the intent of this legislation, but apparently there's some other things going on in the world, and dealing with the Justice Department has got some lawsuits. There's some things going on with the Public Service Commission. I'm going to vote against this bill. I'm not going to argue against the bill. I just want to bring it to the committee's attention so when we get to the floor, if that takes another level, that we're prepared for it. And I just want to make sure everybody was aware there's some other things going on. I appreciate the sponsor of the bill in more ways than you can imagine, but and I appreciate the intent of the bill. I just wanted to share that with everyone. Thank you.
Senator, do you think you can get a little more detail about there's things going on? I don't mean today,
Yeah,
but.
right. Yeah, I can. I can follow up with some more detail for you.
Thank you.
Yeah.
I have a motion and a second. I have a missing vice chair. Should we call the roll?
Senate Bill 786, favorable with amendment. Vice Chair Hayes? Yes. Senator Kramer?
Yes.
Yes. Senator Reading?
Yes.
Yes. Senator Mounts? No. Senator Jackson? Yes. Senator Washington? Yes. Senator Guile? Yes. Senator Lamb? Yes. Senator Hershey? Yes. Madam Chair?
Yes,
Yes.
9-1.
9-1,
Bill
bill
passes.
passes.
Okay. Senate Bill 794.
Senate Bill 794 authorizes an individual who enrolls for coverage or enrolls a dependent for coverage during a special enrollment period for pregnancy to choose whether coverage becomes effective on either the first day of the month the individual receives confirmation of pregnancy or the first day of the month following the date of plan selection. There are no amendments.
Okay, we have a motion and a second. Can we say all in favor of Senate 794? Is everybody okay with that one? Unanimous vote on 794. I didn't hear who motioned and who seconded. Okay, thank you. Thank you. Okay.
Okay.
Yep, Senate Bill 910.
Senate Bill 910 requires certain health insurance policies that provide reimbursement for a service within the lawful scope of practice of a licensed graduate professional counselor, licensed master social worker, or licensed psychologist to reimburse for the service provided by a graduate-level counseling clinical intern, graduate-level social work clinical intern, or graduate-level psychology clinical intern under specified circumstances. There are two amendments requested by the Board of Professional Counselors and Therapists in Maryland Community Health System. Amendment 1 is technical, and Amendment 2 additionally requires insurance policies that provide reimbursement for a service within the lawful scope of practice of a licensed graduate marriage and family therapist, licensed graduate drug and alcohol counselor, or licensed graduate professional art therapist to reimburse for the service when provided by a graduate-level marriage and family clinical intern, graduate-level alcohol and drug counseling clinical intern, or graduate-level art therapy clinical intern, and clarifies that services provided at a federally qualified health center are reimbursable under the bill. So basically, the amendment's putting every professional that's authorized under Title 17 under the scope of the bill, which would include marriage and family therapists, drug and alcohol counselors, and art therapists, in addition to the ones in the bill as introduced.
They're going to work, now they're going to get reimbursed for it, huh? Mm-hmm. Do I have a motion favorable for Senate Bill 910? Thank you, Senator. Do I have a second? Who second? I'm sorry, Senator Lamb. All in favor of Senate Bill 910? Unanimous vote. Thank you.
Yes, ma'am. Senate Bill 326 authorizes a physician assistant to perform numerous additional duties as specified throughout the bill, and it further requires that health maintenance organization quality of care standards include a requirement that each HMO member has an opportunity to select a PA as a primary care provider from among those available. The bill also adds a PA member to the statewide advisory council on immunizations and excludes a PA from the definition of healthcare practitioner with respect to healthcare staffing agencies, and that is in line with how physicians are included in that definition. The amendments remove from the bill provisions relating to involuntary and involuntary admissions to hospitals, includes a certified nurse midwife and licensed certified midwives in the list of healthcare providers who can order a pregnant incarcerated individual admitted to an infirmary. That amendment is on page 2 of the reprint, and then also adds those providers to the list of primary care providers a member of an HMO may select. That change is on page 11. And then finally, the bill as amended requires MHCC to collect and evaluate data relating to the average length of stay in emergency departments for certain individuals who are the subject of an application for involuntary admission. There is no fiscal impact.
26?
What did that last statement? You said people who are applicants for involuntary admission.
Yes, so it's a requirement for MHCC to collect data for individuals who are the subject of applications for involuntary admission to a facility. So it would be like emergency petitions.
Emergency petitions.
I believe that is application for involuntary admission.
Got you. Okay. So not necessarily restricted to like just foster kids or something like that. There's anybody, any adult or child that would be, subject to,
Individuals, it's not
Got it.
specifying foster children.
thank you.
Can I be added as a co-sponsor? All in favor of Senate Bill 326? It's a unanimous vote. Thank you.
Senate Bill 494 is next on the list. This bill extends to all Carroll County correctional deputies an occupational disease presumption for heart disease or hypertension that, one, is more severe than their condition existing prior to that employment, and two, results in partial or total disability or death. And so then accordingly, as a condition of employment, a Carroll County correctional deputy must submit to a medical examination to determine any heart disease or hypertension condition existing prior to their employment. The bill also alters the definition of public safety employee to include Carroll County correctional deputies, making these individuals eligible for these enhanced workers' compensation benefits. And the bill applies only prospectively. There are no amendments. There's no fiscal impact. There was no opposition at the hearing.
I have a motion for Senate Bill 449. Senator Reedy and Senator Mounts. All in favor of Senate Bill 449? It's unanimous vote. Thank you. All
Up
right.
next is Senate Bill 579, for which you have a reprint. As amended, the bill requires each county with a volunteer fire company to offer each volunteer firefighter and retired volunteer firefighter who are or were actively involved in fire suppression activities. That's a new element that was amended into the bill since the hearing. Those individuals are to be offered no-cost preventative cancer screenings in accordance with the latest screening guidelines issued by the International Association of Firefighters. And so each volunteer fire company must maintain an up-to-date list and provide that list to the county. The list is of volunteer firefighters and retired firefighters that meet the definitions in the bill. A county may satisfy the bill's requirements by providing no-cost annual examinations that include the required preventative screenings or applying for a grant from the Professional and Volunteer Firefighter Innovative Cancer Screening Technologies Program to pay for innovative cancer screening technologies. And so the amendments add retired volunteer firefighters to the bill's requirements as I described.
So, and Nathan, I understand, there's a separate fund, right? That pays for, okay.
Yes.
I'm seeing it now from the chair. Okay, all right,
The
thank you.
Volunteer Firefighter Innovative Cancer Screening Technologies
Okay.
Program.
All right, thank you.
Okay. So do I have a motion?
Does the amendment increase?
Can I have a motion for Senate Bill 579?
Capitalized a certain amount in the budget.
Senator Jackson and Senator Hayes. All in favor of Senate Bill 579? Sure. Do we have a pile on? Does everybody want to be a co-sponsor? Okay, pile on.
Everyone?
Senator Washington, you okay? You want to be a co-sponsor?
You have a heart? No, I'm fine.
You don't want to be, okay. You are fine. It's.
All right, and that's it for me.
Okay, the next up on your list is going to be Senate Bill 6, collective bargaining for non-tenure track faculty. Senate Bill 6 generally extends collective bargaining rights to the non-tenure track faculty at the University System of Maryland, Morgan State University, and St. Mary's College of Maryland. You do have a reprint in front of you, and the amendments offered by the chair begin at page 3 Essentially, what they do is first define what a fully online institution is, and then excludes individuals employed at such an institution, which is really targeting the UMGC model to exclude them from the bill. The bill also excludes from the bill positions that are fully funded through a grant or contract or other clinical revenues.
That's it?
And that is the bill.
Okay. Do I have a motion? Sure.
Just a quick question do we know if there's going to be money in the budget to cover the cost of rising salaries for this?
There's money in the budget for the schools. Lots of it.
Lots of money for the schools? That can go to, do we know, go to compensation? Do we know? I mean, anything specific for this?
There's nothing specific in this budget, however, we will be looking at Senate Bill 28, which is the arbitration reform bill with the constitutional amendment, which would require that anything that has an appropriation, they must come back to the General Assembly to ask for that appropriation.
Okay. Thank you.
Senator Washington?
Just a question. This isn't the bill that only allows for 2 colleges. This is for all the colleges, right? All public
Except
colleges?
for UMGC, which is a fully online institution as
Correct.
defined in the amendment. Yes, it applies to all of the institutions.
Got it. Okay.
And of
Thank
course,
you.
you know that UMGC has people all over the world, so that's why we're not.
Of course. Yep. Thank you.
Okay, Senator Reedy?
Yeah, I feel like we've spent more time in the committee on the next bill than this one, so I forgive me, but so what is an example of a non-tenured track faculty member? Like who is that?
The bill defines a non-tenure track faculty as a full-time, part-time, or adjunct non-tenure track employee of a system institution whose primary assignments involve academic instruction, including teachers, researchers, and department heads, and those in comparable
Okay,
positions.
so it could be somebody doing a summer history class, history 201 class, or it could be somebody who is overseeing the administration of a department, and they're like the deputy of something or the assistant to somebody, correct? Or
Subject to the fact that the primary assignments must involve academic instruction. So if it's a department head, they have to also be a teaching department head where they're teaching classes.
okay. And why, I know in the next bill, we're exempting some other schools out. Why are we not exempting, why is Morgan State and St. Mary's College and others not getting the same exemption here that there are for the graduate assistants?
I think it's based on the fact this is for faculty, and faculty at those institutions is structured differently than the graduate assistant are structured at those institutions.
Okay. Okay. Well, I just, hey, times are tough budget-wise, so just hope everybody understands what's going on. Sure.
Keep having kids go to that stuff.
Families are doing well here.
Senator Kramer?
Thank you, Madam Chair. And apart from the nonsense, I would just like to say that this bill is heavily amended. It is not the bill as introduced. It is a significant compromise, and I appreciate the fact that the committee chair and the Office of the Senate President, along with those who will be affected by this legislation, have spent a tremendous amount of time working through where the bill is at the moment. So I very much thank you and appreciate that. The bill has been before us in the past, and I just think that this represents a significant compromise by all the folks involved, and I would move favorably as amended on the bill, Madam Chair.
Thank you. And Senator Kramer, thank you. It really is the work of the Senate President. Do we have a second favorable motion? Senator Lamb, okay. All right, let's call the roll, Tammy.
Senate Bill 6, favorable with amendment. Vice Chair Hayes. Yes. Senator Kramer.
Yes.
Yes. Senator Reedy.
No.
No. Senator Mounts.
Nope.
No. Senator Jackson. Abstain. Senator Washington.
Yes, and explaining my vote.
Yes.
I've heard from a lot of my constituents that are, my district abuts the University of Maryland. And so a lot of the professors or the folks that are impacted by this bill live in my district. And so I'm voting for them in favor of this bill, and that they will be, hopefully have some protections that a lot of our students, that we haven't had in this state. So looking forward to voting for this, so I vote yes. Thank you.
Thank you, Senator. Senator Guile?
Senator Guile, yes. Senator Lamb? Yes. Senator Hershey? No. Madam Chair?
Yes.
Yes. 6-3, the bill passes.
Senate Bill 84, as was alluded to, generally authorizes collective bargaining for a graduate assistant, which is defined as a graduate student who is a teaching, administrative, or research assistant or assistant in a comparable position as a fellow or postdoctoral intern at the University of Maryland College Park campus and the University of Maryland Baltimore County campuses. You'll see on the reprint at page 3 where the bill is limiting by amendment application of the collective bargaining provisions to those 2 campuses.
Yes, Senator Washington.
Thank you, Madam Chair. Why just these 2 schools?
May I?
Yes.
That's a very good question, and again, as part of a lot of compromise that what happened, it was concluded after we heard from the University of Maryland system, which comes in and gripes about anything that's supportive of labor on their campuses. Part of that was all the campuses are different, that the University of Maryland College Park, the University of Maryland Baltimore County are very different than, and they listed all the other campuses. So we heard them come in, what they had to say, and it was agreed that, okay, the flagship campus, College Park, and University of Maryland Baltimore County would be included in the bill. And I mean, I'm disappointed it left out all the other institutions within the system, but that's what the agreement was, that, okay, these are the big campuses that are comparable to the other Big Ten schools, the vast majority of which afford their graduate assistants this ability to bargain collectively. The other institutions in the system were not on that scale. So that's how it came to pass, that it will be applicable to these 2 campuses.
Yeah, I understand the compromise, but just these 2 schools just seems a bit unfair and not something that I would support, honestly. I would much rather there be all the schools if we were to move a bill like this, because it's parity amongst everybody. And so I'm really concerned that it's just these 2 schools. And I would like for us to, if we can further compromise so we include everybody. But I just don't like the way the bill is here. And so I can't support it because it's not all the schools that would be impacted by it.
Well, Senator, if I may, I would ask that you please support it, and I don't disagree with you. Look, it's been my bill for, I can't tell you how many years at this point.
Senator, this is your
The chair can tell you how many.
This is your time.
Oh.
Why change your big bill?
But the point being that 90%, my understanding is 90% of graduate assistants will be pulled into collective, having the opportunity, if they choose, to bargain collectively the way the bill has been amended with the 2 major campuses. I don't disagree with you, but we have the opportunity to help 90% of these students in the process.
This has been pretty heavily negotiated between the senator and the president's office and the campuses. You know, sometimes you have to start, you know, like it's sort of how to eat a dinosaur one bite at a time. So after 5 years, I'm kind of relieved to see us doing something. That's just my opinion.
Madam Chair, as you know, I support the bills that support our unions, and I'm a strong union supporter. But the flagship is in my county, and I represent them, and so I would like to talk to them to see where they are on it. I don't know if they've submitted a letter of support saying they're okay with this or not. So I would like the opportunity to have a conversation with them and see where they are on it, because just having them and them being in my district and in my county, is really something that I want to see where they are.
Senator, I see a representative of the flagship in the audience. If you'd like to ask now, or if you'd rather wait, that's your call. What do you think?
No, that's fine. I'm not going to ask them now. I mean, I don't want to put them on the spot, but I would like to.
You're asking to hold the bill?
Yes.
Yes, sir. You get a hold. Thank you.
Thank you.
Okay, next bill, Amber.
Next bill is Senate Bill 582, which generally prohibits a person from sending a check or other negotiable instrument to an individual if it is sent in connection with an offer to extend credit to the individual and the individual has not requested any extension of credit beforehand. An individual who is sent a check in violation of the bill is not liable unless the individual actually receives and negotiates it. And a person that violates is guilty of a misdemeanor and on conviction is subject to a fine up to $500. You do have a reprint in front of you, which makes both technical and substantive changes as proposed by the sponsor, supported by the Maryland bankers, and offered by the chair. So the First Amendment here applies the bill to or strikes the definition of creditor, because we're gonna, the amendments apply the bill to a person rather than directly to a creditor, which would be someone that is licensed and is already being overseen. But would also be captured in the definition of person, so it expands that application. But it doesn't apply to a convenience check that is sent to an individual for the sole purpose of accessing an existing credit line. And then on page 2 of the bill, we've also expanded the bill to explicitly cover unsolicited offers to purchase real property. As you might remember from testimony, there was a lot of information about people who had been sent checks to purchase their property, and then when they negotiated those checks, they would have people come back and try to take possession of the property under the theory that they hadn't paid off of this loan. So that's what the bill does now. There's no fiscal impact, and there is no longer any opposition.
Do I have a motion for Senate Bill 582?
I'll move favor.
Senator Mounts. Do I have a second?
Second.
Senator Reedy. All in favor of Senate Bill 582? Senator Washington, you okay? Yes. Unanimous vote. Thank you. Okay. Next bill.
The next bill is Senate Bill 589, which, as amended, prohibits enforcement of Title VII of the Business Regulation Article, which is related to the licensure and regulation of collection agencies, until the resolution of a certain case that is currently pending appeal. And this would be enforcement against specifically a property manager that is defined. So you have a reprint in front of you. It's a very heavily amended bill. It was a compromise that the sponsor brought, which generally strikes the bill as introduced and exempts property managers, strikes the bill as introduced, which would have exempted property managers from being licensed as a collection agency, and instead just delays enforcement against property management until the Christine Smith versus Bozzetto Management Company is resolved and reached a final disposition.
Some amendment. Okay. Do I have a motion for Senator Kramer's 589?
Favorable as amended.
Okay, so we have Senator Kramer and Senator Reedy, and Senator Lamb has a question.
Yeah, thank you, Madam Chair. So just reading this from what Council just described, so there's an outstanding case, I guess, Smith versus Bozzetto, that's still pending a final decision, right?
That's correct. It's on appeal.
It's on appeal. The court has not stayed their decision while it's on appeal, right?
They have not.
So is this the equivalent of like a legislative stay? Are we doing this stay by legislation? We're essentially holding the enforcement until the court makes a decision, right?
That is the bill.
So we're like doing a legislative stay by legislation.
That's how you do it.
Well, we're doing the equivalent of a judicial stay by legislation.
That's,
Have we ever done this before? Have there been other examples where we've done something like this before?
we've had compromises.
Had compromise is similar, but I don't know if we've actually put in bills.
Senator Kramer?
Thank you, Madam Chair. Colleagues, a quick refresher. This bill came in drafted in such a way that it reflected the outcome of the only on-point circuit court case in the state on this specific issue. And in fact, the circuit court judge, in her opinion, and she is an exceptional judge and has a spectacular reputation, she even noted that the Attorney General's commentary in the cases that they believe gave them the ability to claim that property managers are debt collectors. Those cases are not on point. She did considerable research in her finding and then issued her opinion. And if I may, just a couple of quotes from her finding that include the following. Nothing in the legislative history of the Maryland Collection Agency Licensing Act, which is what the Attorney General has claimed gives them the authority to assert that these property managers are debt collectors. Nothing in the legislative history of the MCALA supports the conclusion that the General Assembly intended to include a person incidentally engaged in the collection of consumer debt, such as property management company, as a debt collection agency. Now, what we heard from the AG when they came was, well, we have a case pending, so we shouldn't do anything. I agree with them. Since we have a case pending, they shouldn't do anything. So I asked the Attorney General directly to General Brown if they would do the same that they're asking of us. Just don't enforce pending the appeal on this, since we have the First Circuit Court case on point saying these people are not property managers, and they said, no, we're going to continue to pursue as debt collectors, we're going to continue to pursue them as debt collectors. Hence, you have the amendment before you. What's good for the goose is good for the gander, and nobody should be acting on this, as I see it, pending the outcome. And this was a huge compromise that, okay, we're not going to legislate as to whether they are or are not. But we have a circuit court case now that says they are not. Let it play out. And until it plays out, just stay enforcement of it. And let ultimately, if it goes to the Court of Appeals, let's allow it to play itself out And in the meantime, the chaos that has been created within this industry by what is happening will settle down, and we're respecting what the court has found, not just a random assertion that this is the way a particular AG is enforcing this. So I think this is a very valid and appropriate way to address the issue as a compromise. I was willing to say, okay, let's back off legislating it, pending it, but let's just let it rest. And if you recall, at the hearing, we asked the Office of Financial Regulation how many complaints they have had, and they indicated a total of 4 in the last 6 months without any indication as to whether there was any validity to those cases, just that they had had 4 complaints in total. So I think this resolves the chaos for the time being. It brings stability to all parties, and let it play out in the courts. And if the courts find otherwise, but we do have a circuit court unequivocally saying that these individuals are not debt collectors, period, end of story.
Thank you, Senator. Senator Lamb?
Question. Maybe you don't have the answer to this, but then why did because the circuit court could have issued a stay, right, pending, the appeals process. They chose not to, I guess, in this.
I don't know whether the appellate court has taken up that issue. I think they could. What the decision of the circuit court was, here's the sentiment of the court, and now evidently the Attorney General's office has chosen to appeal it.
Mm-hmm. Well, I mean,
it only
it's not
happened
uncommon
in
that
December.
Courts will stay a decision pending
this is a
appeal.
fresh case in December, mid-December, mid to late. And the court was right on point and listed and went through all the assertions in its findings saying, no, what they are doing is not debt collection, and it was never intended to be debt collection. That's the bill that I introduced. But I'm saying, okay, if the Attorney General's office is not willing to accept what the court's finding was, then let's just let it rest, pending the outcome. And I don't think that's unreasonable. And I think it's an appropriate step for us to take.
Okay. I was just wondering why the court didn't move forward with their, because they could have done a stay also, right? I mean,
I'm not sure that the court anticipated, like I said, it's just been in December. Court may not have anticipated the appeal, and I don't know when it was filed. But it's before us now.
I think what makes it so difficult is they own or they manage these properties. They aren't just out collecting debt all over. It's particular properties. And as a landlord, if I couldn't collect rent, what's the point? I mean.
And when they say collect rent, it's sending a letter, and this is what we want them to do. These property managers send to the tenant, listen, your rent check didn't come in. Want to give you the heads up. Would we rather have them do that or go immediately into the courts and file for possession of the property? They are doing, and this is incidental to all their other property management, but it seems to me we want them to be able to reach out and say, hey, listen, because otherwise, what's their alternative? They go straight to the court and seek possession of the property. And by the way, once there is a finding, and should the court, give a judgment, that goes to a licensed debt collector. Property managers never pursue, legally anyway, a finding of the court for a judgment. And then, it gets turned over to a licensed debt collector. These folks are only the in-between, the intermediary, trying to keep it from going to the court. Once it goes to the court, it's out of their hands. And I think we want them to be able to do that, quite frankly.
Senator Bile?
Yeah, I mean, I agree with Senator Kramer's assessment on this. I mean, I think that landlord-tenant situation, the property management, they're so heavily regulated anyways. We have really robust protections in place for tenants. I don't understand why we would extend this to property managers. I'm not certain, but I don't know. I think a court could issue a stay on certain grounds of constitutional. If there's just a difference of opinion on the interpretation of the enforceability of the application of a statute, I mean, maybe it's a stay if it would be as to that particular litigation, but I'm not sure as to a stay as to an attorney general's enforcement broadly of the law. So I'm not certain about that, but at any event, I support the bill. I think it's a good bill. So thank you, Senator Kramer.
I had a motion from Senator Kramer and a second from Senator Reedy. Can we call the roll?
Senate Bill 589, favorable with amendment. Vice Chair Hayes.
Yes.
Yes. Senator Kramer.
Yes.
Yes. Senator Reedy.
Yes.
Yes. Senator Mounts.
Yes.
Yes. Senator Jackson. Yes. Senator Washington. Yes. Senator Guile. Yes. Senator Lamb.
How we're going about this, but I'm going to be a yes.
Senator Lamb, yes. Senator Hershey.
Yes.
Yes. Madam Chair.
Yes.
Yes. Unanimous.
10-0 unanimous vote. Okay. Next, we have Senator Ferguson, President Ferguson's bill, Senate Bill 770. Amber?
Thank you, Madam Chair. Senate Bill 770 establishes Maryland's future board within the Department of Commerce to, by January 1, 2027, develop a visionary plan that imagines a state that is equitable, prosperous, and livable, and provides opportunities for all residents to thrive. The board must annually evaluate and revise that plan. And the bill also establishes Maryland's Future Fund as a special fund administered by Commerce, specifically to fund projects that the board annually recommends and ensure the economic strength of the state. You do have a reprint in front of you. The First Amendment is technical, and then the substantive amendments are gonna first appear at page 4. Which is just where this is a 7-person board as it came in. This First Amendment just adds the comptroller as a member of the board, so the board will now be an 8-person board. And then at page 8, there's uncodified language that was discussed at the hearing and presented to us by the comptroller and the bill sponsor, requiring the comptroller to study certain trends and identify certain growth industries. This report is due by December this year.
We have a motion from Senator Guile. Do you have a second?
I got a question.
Please, can you second it and then have your question?
I'll second. I might want to hold it.
Okay. All right. Well,
I wanted to ask Amber a question first.
okay, ask Amber a question.
So is this the bill that I had asked the president about the exemption from procurement and the effect that it might have on MDWBs?
Let me check and see if this is the one. He did ask it in one of these, but there is a state finance and procurement provision in here, but the only procurement provision that it's doing is adding the fund to the list of funds that do not get accrued their interest earnings to the general fund. But
It looked like what they did instead was on page 7, they left the am I reading this right, that they're leaving up to the department to set the regulations as it relates to carrying out the state procurement?
Not to the procurement, just to carry out the subtitle and put the board into place and any projects that are recommended, that's done by Commerce. And then it only has the state finance and procurement article in there to add the special fund as one that does not have interest accruing to the general
So
fund.
maybe this isn't the bill. Okay, all right, I'm good. Yeah, okay, I'm good.
Because I'm reading all about the treasurer. Yeah, okay, we're good.
I don't think this is the bill that you, it might have been the bill you asked on, but it does not affect their procurement at all. It doesn't have any of those provisions.
One of them comes up with- Okay, we have a motion. Did you second? Okay, I'm trying to get a second and then we can have lots of discussion.
I'll second.
Okay, go ahead. Questions? You want to start, Senator Hershey?
Thank you, Madam Chair. Just again, going back to these funds that we keep creating, is there money that's appropriated to this fund?
Yes, Senator, I believe.
Is that one of the ones on the list?
Oh, there's, I think it says 214 one fund and 89 of another fund, so we've got a lot of funds in the state.
And the bill requires one contractual staff within Commerce.
Right, and Commerce says they can pick that
Or-
up, that's a $143,000 fiscal note, but
Some of it's still the B&T and they approved it. That helps at all.
well, Madam Chair, honestly, we keep creating funds, and I don't know if they're funded or not, if there's an appropriations that's put aside, or if it's one of those, they may fund it down the road, so I'm just trying to see if there's, I can ask, I guess, on the budget.
There's no mandate in the bill, but I was told there is money in the budget. I do not have that budget number as the budget was just
Okay,
released.
I can bring it up on budget day. Okay, thank you.
Okay, so we have a motion and a second. Other questions? Senator
There's
Reed?
Thank you. My question is a little bit different from the funding side, although I do agree that's a good question. We've got a visionary plan, and this talks a lot about forward-thinking vision. There doesn't seem to be anything in here, and I'm just wondering if I'm missing it, that's studying what we're doing wrong now. Because the whereas clauses seem to indicate that we're rich in assets, but we are, and we have significant competitive advantage, and yet somehow we're lagging behind the nation in economic growth, population growth, and personal income growth. And there's some pretty bad statistics in here that look like it come right out of like the Senate Republican caucus talking points about where Maryland is. But everything seems to be focused on like what's the magic thing we can find in the future. And I'm all for looking to the future. Don't get me wrong. I just wonder if there ought to be something in here that talks about maybe just taking taking a couple of meetings and looking at what we could do now on the current stuff to fix some of the stuff we've got. So is there anything in here about examining current, sort of our current tax code and our current business and regulatory environment?
Yes, Senator Reedy, the uncodified language that was added by amendment requires the comptroller to do an economic growth trend study that's focusing on what are the industries now and where can that we have and how do we grow them. So I think that's what it's targeting. I don't know if it has all the elements you would like, Senator Reedy, but
Yeah, I mean, I'm glad that none of this in here looks that, although I don't know about the fund, but none of this really looks bad to me, but I just think it's like, I don't know, man. It's like I'm riding a bicycle right now and I'm trying to plan for my spaceship when we should just probably, look at how we could get a car. So anyway, all right, I'll leave it alone. Thank you.
Or a potato. Senator Washington's next.
Thank you, Madam Chair. I was looking at this bill, and I think it's a really great bill, but the Senate President did mention specifically aerospace in his talking points when he presents it at the hearing, and so I don't see it here. I just see advanced manufacturing, which could be anything, honestly, and not just something that should be focused on what's happening in the future and the constant investments we have here in the state and the industry of aerospace being so big it is. I wonder if there's an opportunity to add something like that in there more specific other than just the things that they have here, robotics and automation, artificial intelligence, advanced manufacturing, data aggregations, and other industry. Maybe those things do cover it, if you can just explain that to me. But
Sure. So I think this bill, and there are a number of bills that the president has talked about in his package. I think one that you also had questions on is coming up later and does add some prioritization to a nod to some of the questions you were asking at the hearing. But for this one, it stays very broad because it's looking at the future and what is coming down the line, they don't know yet. So it's just supposed to be very broad that they can basically capture anything under the umbrella.
okay. I'm good.
You're good? Okay. All right, Senator Mounts.
Yeah, thank you, Madam Chair. I had a chance to ask the Senate President a question at the hearing, and he had a good job responding to the question. And I understand the intent of the bill, and you always have to have a vision to know where you're going. However, the issue that we're dealing with is not the future, it's the here and now. And that's the part of this bill for me that is really missing. It doesn't focus on what we have right now and what the problems we have right now. And that's why our economy is faltering. And we have industries that have been successful that are lagging behind. We can look at industries we've lost. I'll just give you one, for example, forestry. I mean, there is enormous potential in forestry, and the state of Maryland, for some reason, just ignores forestry. You hear me talk about commercial fishing, and I can give you countless examples where the state of Maryland has unilaterally, I mean, really set this industry back. And I can get into small business. And small business has been absent from all these discussions about the economy. I went to the State of the Union. I heard the governor talk about his vision for the future of Maryland. I talked about, I just threw a rural industry. For some reason, commercial fishing is easy. And I heard the Senate President talk about the future of Maryland. But not once has our leadership said these words, small business. Small business is the backbone of the economy of the Eastern Shore. And that's where you get out of Annapolis and you hear about the political divide of the Annapolis. And I think small business right now is really hurting in our state. And the bill, to me, is missing that. You got to have a vision to move forward, but you can't move forward if you don't know where you're standing. And I just wanted to share that.
We had Senator Guile motion, Senator Kramer second. I think you should call the roll, Tammy, on 770.
Okay. Senate Bill 770, favorable with amendment. Vice Chair Hayes.
Yes.
Yes. Senator Kramer.
Yes.
Yes. Senator Reedy.
I'm voting no, and just explain my vote. I appreciate the sentiment behind trying to be future focused. But we've just got a lot of stuff that's low-hanging fruit that seems like this General Assembly just keeps ignoring. And we've got to make a change to what we're already doing, and that would make a huge difference. So my vote is no.
Senator Mounts.
No.
No. Senator Jackson. Yes. Senator Washington.
Yes.
Yes. Senator Guile. Yes. Senator Lamb. Yes. Senator Hershey.
No, and I'm just going to say the same. I think as we're going to continue to create these funds, we need to see if these are appropriated and know more about what's going on in the fiscal note to see if we are getting any type of benefit from doing these funds or not. And I'll ask the question when we have the budget, if this is funded or not, but just to continue to pass all these different funds that don't have mandated appropriations to them essentially sounds meaningless to me. So I'm voting no.
Madam Chair.
Yes,
Yes.
7-3, bill passes. Okay, next we have 820, Senator Hayes' bill.
Senate Bill 820 authorizes the Alcohol, Tobacco, and Cannabis Commission to issue a citation or other charging document to a person who has violated certain subtitles of the Health General article. The executive director of ATCC may also seize, confiscate, and destroy any unauthorized consumable product. And that's defined in the bill, as well as the circumstances under which the executive director may seize the items. Additionally, the bill prohibits a retailer from distributing, selling, exposing for sale, or advertising for sale an unauthorized consumable product. Expands the prohibition against advertising to a minor to include kratom and Finibut products, and imposes criminal and civil penalties for specified violation. Finally, the Department of Health must notify ATCC of any changes in the regulatory status of an unauthorized consumable product. You do have a reprint with amendments. These are compromise amendments that were worked on with ATCC, MDH, the Governor's Ledge Office, and some industry advocates. Basically, on page 4, we're just simplifying language. It has the same meaning, but it just references the whole subtitle 2E rather than referencing specific sections of 2E and 2F. Just makes it a little more easier to understand. And then on page 5 of the bill, the language is restructured because kratom isn't just outright illegal in Maryland. So it was restructured to nod that to specify when it would not comply and when it would become an unauthorized consumable product. That's all.
All right, so Senator Hayes, and did you second Senator Perry? I second. Thank you. All in favor of Senate Bill 820? All in favor of Senate Bill 820? Okay, unanimous vote, thank you.
Great bill.
Senate Bill 920 authorizes a means for covering the management and administrative costs for an eligible fund manager under the small minority and women-owned business account. Specifically, the bill establishes that Commerce may authorize an eligible fund manager to receive, use, and retain a management fee of at least 1.5% and up to 3%, calculated as a percentage of total principal for each loan made. A management fee is in addition to other grant monies already allowed to be used by an eligible fund manager. And finally, Commerce may establish an annual cap on the cumulative amount of management fees an eligible fund manager may receive. Amendment 1, proposed by the sponsor, offered by the chair, conform the bill to its cross-file and literally just strikes 4 words on page 2 of the reprint, saying that the money is in addition to rather than in lieu of.
Senator Hayes and Senator Guile, all in favor of Senate Bill 920? Unanimous vote, thank you. All right, that finishes the yellow. Now we're going to go to the purple, and you have a separate pile of amendments. It came from Tammy. Who's up?
I believe I am still up with Senate Bill 28. It should be a 1-page pink list, a single sheet.
Oh, I'm sorry. I got it. Thank you.
Great. Senate Bill 28 is the Arbitration Reform for State Employees Act, which proposes a constitutional amendment that, if approved by the voters at the next general election, requires the governor to include in the annual budget bill the appropriations necessary to implement and fund all terms of memorandum of understanding or binding arbitration involving the state institutions of higher education, and the Maryland Environmental Service, and the exclusive representative of each of their respective employees. Contingent on the patches of the proposed constitutional amendment and its ratification, the bill alters the statutory collective bargaining process for most state employees by establishing binding arbitration in the event of an impasse in negotiations. It requires the selection of a neutral arbitrator to oversee all aspects of the bargaining, expands the matter subject to negotiation, and makes other conforming changes. However, it is important to note that matters that require an appropriation or other legislative action are contingent on the General Assembly's approval of the appropriation and the arbitrator's decision related to wages and the limitations of the state budget. You do have a reprint. These are the amendments that were proposed by stakeholders and as adopted by Budget and Tax, who was primary on the bill and has voted it out. Amendments generally begin at page 4. And primarily what the amendments do is exclude higher education institutions from application of the arbitration provisions of the bill. This also does not affect what was done last year for the BWI Airport Fire and Rescue Department bargaining. That stays in place as well. And so on page 5, this is just, instead of repealing the current process that is used, it's allowing the institutions of higher education to continue using that same process that they currently use. Most of the rest of the amendments through here are going to be just conforming changes to exclude higher education, except at page 8, they exclude pension benefits from matters that can be collectively bargained.
It's a constitutional amendment.
Oh, sorry, they include, yes, they exclude pension benefits, yes.
Do I have a motion for Senate Bill 28?
I'll do my best.
Do you have a question, Senator Hershey? Yes. Okay.
Again, it's looking like a bad year to be in the university system of Maryland, but jeez, good gosh. I assume that they are still unfavorable with this. Is that accurate? With all the changes?
They are generally carved out of the bill and can continue to use the same process that they are currently using.
So they're carved out, okay.
Yes.
So on the last part, because this is a constitutional amendment, this will be going into Maryland's constitution, right?
Correct, yes, if approved.
Wow, it must be important. But the constitutional amendment, this on page 18, is the top of 18, is that the question that's going to be on the ballot?
Page 18, sorry.
It's finishes.
So this is the general, it is not the exact language that they will include on the ballot. They have, the State Board of Elections does that to make sure that the language is perfectly clear. But this is a general understanding of what the amendment would include.
Okay, I mean, the reason I ask, because it does say something. It says question, there's a blank, I think,
Right.
for the, whatever question it is on the ballot, then it says constitutional amendment. But what begins on page 18, obviously you'll be asked to say either yes to, either for or against this constitutional amendment. But it just seemed to be, if this language was in the bill, I wondered if this language was what had to be on the ballot. You did a very good job of explaining the bill, but obviously there was a very lot of explanation to fit into, 2 sentences here. So I just wondered if that was the requirement that would be the language, or does the language get to be potentially changed?
It could be potentially.
It could be potentially changed, so. Okay, thank you very much.
So do we have our motion second? Well,
No. Senator Kramer, motion favorable. Who seconded it? Senator Land? All right.
28?
Can we call the vote, please?
It's a party.
This is amended by B&T, right?
Yes, this was amended by, as amended by budget and tax.
Senate Bill 28, as amended by budget and tax. Vice Chair Hayes?
Yes.
Yes. Senator Kramer?
Yes.
Yes. Senator Reedy? No. Senator Mounts?
No.
No. Senator Jackson? Yes. Senator Washington? Yes. Senator Guile? Yes. Senator Lamb? Yes. Senator Hershey? No. Madam Chair?
Yes.
Yes. 7-3, the bill passes.
Next on the list is Senate Bill 242. We are also second on this bill with triple E. We have heard, we voted a similar bill to this, Senate Bill 418. This is just doing for service members what we did for the international, or the other services, but it's explicitly authorized as an active service member or their spouse who relocates to the state due to orders for service and holds a license issued in another jurisdiction to practice under that license in Maryland. if the individual submits an application and specified documentation. If an active service member or spouse is authorized to practice under the bill's provisions, the individual may practice only in the discipline and scope of practice allowed by the license in their home jurisdiction, and the licensing authority in the state may not require another license unless the individual seeks to practice outside of the authorized discipline or scope of practice. It's a 97-page bill, so I've given you a reprint that is just page 1 and page 10 of the bill. While there are some technical amendments throughout, the primary amendment is at page 10, and it's the language that ensures an individual practicing under the bill is subject to discipline in Maryland. This is the same amendment that we added to Senate Bill 418 at the request of the dentist, and we've added it in this bill as well.
Senator Guile moved favorable. And Senator Lamb seconded. All in favor of taking care of our service members in Senate Bill 242. Unanimous vote. Thank you.
Senate Bill 528. This bill has been on the voting list before, but just as a refresher, it generally prohibits a video streaming service from transmitting the audio of a commercial advertisement in a louder manner than the audio of the accompanying program. A violation of the bill is an unfair, abusive, or deceptive trade practice.
I have a question on this bill, and I know we've had it for a while. So I had an Attorney General request. I don't know, Madam Chair, if I could ask the question. Thank you. I had an AG request in, and it has not come back. But basically, the question that I had, which was, I'm coming up with this myself, but people that had concerns said that the Attorney General's Consumer Protection Division has to enforce this, right? As far as I know, yeah.
It's an unfair, abusive, or deceptive trade practice, which is enforced by them.
And candidly, I hate the ads that come on occasionally. It doesn't happen that often. It comes on sometimes blaring loud. I understand why people don't like it. But apparently the standard for this is technical and science-based. And so that the FCC regulates it at broadcast TV, and they have a scientific standard for it. But if the Attorney General here finds a violation of this, according to the bill, the streaming service could claim that they're in compliance with FCC rules. But then when the AG goes to the FCC and says, is this right? The FCC says, well, we don't really regulate streaming. So you could end up in this impasse where the company asks FCC to validate their compliance, but the FCC won't, but the AG is not going to be able to prove that they are out of compliance. So you're in this weird impasse, which is why I sent the Attorney General letter, and I sent it back on Monday or Tuesday, haven't heard back. And I know, they're probably getting 8 requests a day for AG opinions. I'm not complaining about them. I'm just saying that's what I was trying to find out was, does this even do anything, or are we going to end up in an impasse?
So I think the intent of the bill is to fill that gap of where the FCC regulates for broadcast TV and to put regulation in on streaming services that are similar.
But you understand, not to argue with you, but if we say the AG could say that, but how are they going to penalize a streaming service if the streaming service says, well, we're meeting all the consistent FCC standards, and then the AG says, no, you're not. Well, who decides? Because the AG is not an authority on FCC standards.
I would say a court would likely decide in that situation. The AG would have to bring a case.
So my wife and I are watching something on TV. We use a lot of streaming services, and something we get mad because this car commercial keeps blaring really loud, or it's happened a few times. We end up in a law. It just seems like a lot to do about a bill. It just doesn't seem like this bill's going to work that well, and it's no disrespect to the sponsor. I understand its intention. That's what I was questioning. But I guess the answer is we'll find out in court. So, okay.
Okay.
Not really. I was just going to say, the AG's already said that his letters aren't worth anything. So I don't know if it's even worth waiting on it. I'm just saying, he said his letters of advice don't mean anything. So I don't know if we should put a whole lot of weight on that. Move favorable.
Second.
Please, and Kramer, can we take roll calls, please?
It is with amendment.
Senate Bill 528, favorable with amendment. Vice Chair Hayes?
Yes.
Yes. Senator Kramer?
Yes.
Yes. Senator Reedy?
I vote for this bill that will do a lot.
Yes. Senator Mounts? No. Senator Jackson? Yes. Senator Washington? Yes. Senator Guile? Yes. Senator Lamb? Yes. Senator Hershey? Yes. Madam Chair?
Yes.
Yes. 9-1, the bill passes.
I was waiting for a whole bunch of questions from you about who's covered and who's ready. Next on the list is Senate Bill 763, which establishes the Maryland Growth Initiative within TEDCO to support the growth of startup companies in the state. The bill also establishes a related special fund, the Maryland Growth Initiative Fund. The governor must include in the annual budget bill an appropriation of $5 million for the initiative, and TEDCO is authorized to adopt regulations to implement the bill. You do have a reprint. There's amendments that appear on pages 3 and 4. Generally, Amendment 1 at page 3 just clarifies that the funding established for the initiative is a purpose, or the initiative as established is a purpose of the fund, to be clear on that. And then at page 4, this is where they've added prioritization for companies that are located in high need or economically distressed geographic area of the state as determined by the corporation.
Thank you. Senator Washington moved. Who second? Second. Senator Hayes second. All in favor of Senate Bill 763? It's a unanimous vote. Thank you. Okay.
Next on the list is Senate Bill 894, and you probably have lots of paper in front of you on this one.
I can save Amber a little bit of work before she goes over it. Madam Chair, Senator Hershey had some amendments that he was working on, and in the interest of avoiding a penny debate on the floor, and because Senator Hershey is such a reasonable person, I suggested to him that, and I realize we don't have much time, that I talked to him about it.
So we're gonna
If it's
hold
possible
that
to
bill.
hold it, I would appreciate it. Thank you.
Okay, we're holding 894.
really want his amendment? It's only got a hole.
Sometimes he has good ideas.
Ready? Okay. Senate Bill 865 is up again, and you have a reprint that has one additional amendment from when we discussed it yesterday. The bill is introduced, expands the duties of the Maryland Insurance Administration's work group on private passenger automobile insurance affordability to include the development of concrete legislative recommendations to reduce premiums, including specific recommendations regarding the use of territorial rating and other rating factors that may contribute to disparate impacts, and extends the termination date of the work group by 1 year to June 30th, 2027. The bill also alters the membership of the work group to add 2 representatives of a nonprofit research or consumer advocacy organization. The work group must submit an updated report on its findings and recommendations to the Governor and General Assembly by January 1st, 2027. There are 2 amendments in the reprint. Amendment 1 strikes the preamble. Amendment 2 adds a representative of the National Association of Mutual Insurance Companies and an actuary to the work group. And the amendment, the change that was made from yesterday, it now has language saying that the work group needs to consider the impact on rates across the state when making recommendations on changing any territorial or other rating factor.
Second.
Thank you, Senator Washington. Senator Hayes, can you just vote? All in favor of Senate Bill 865? Unanimous vote. Thank you.
Even though he held my bill that I've worked on for 20.
Another couple days.
All right.
All right.
Up next. Oh, no, there's one more bill on the voting list, followed by 2 withdrawals. But the last bill for the committee's consideration is Senate Bill 90. which as amended and shown in the reprint before you expands the workers' compensation occupational disease presumptions for specified public safety employees, generally firefighters, who have hypertension, by establishing that an employee has demonstrated disablement from hypertension if the employee has been diagnosed with hypertension, has been prescribed medication to treat hypertension for at least 90 days, has worked in their role for at least 2 years, and files the claim while still employed.
Thank you, Senator Kramer. Can I have a second?
Second.
Would you like me to describe the amendments?
No.
Okay.
As amended.
As amended, Senate Bill 90 as amended.
This is Senate Bill 90, can I be on as a co-sponsor?
I'd love to have you as
Wasn't on there
co-sponsor.
already?
So can we add Lamb and Guile as co-sponsor?
The only person on here so far is the
Kramer and
chair.
Reedy?
Okay, please add me.
I'm sorry?
Pile on. Okay, everybody.
Everyone.
Thank you all.
Very good.
Firefighters appreciate it. Another 5-year bill. Okay, I'd asked a motion unfavorable withdrawn for Senate Bill 785 and Senate Bill 952. Can I have the motion?
Second.
And Senator Washington and Senator Reedy, all in favor of the unfavorable withdrawn? Unanimous vote? Okay, I think Senator,
Yeah, I apologize, Madam Chair. We moved quickly through a bill that was approved unanimously, and there were a number of amendments proposed. There was an amendment at the hearing, and we didn't really object to that amendment, but I believe that was actually included in the bill that we voted, and I think that would change the Senate bill from the House bill, and it would also bring a lot of opposition. And with that, in regards, that was adding additional provider groups. This is the intern bill that was promoted by For All Seasons for mental health. And we did not want to include, my intent was not to approve that bill with those other provider groups. So I could I move to reconsider that vote? I voted for it to see if we could take that amendment off and then reconsider the bill.
what I'd like to do is do the reconsideration, take the amendment off and hold it till next week.
Okay.
Because there's some other questions have come up while we're sitting here, because my text messages don't stop coming in.
Yeah.
So I'd like a vote to reconsider Senate Bill 910. We have a motion and a second. All in
Thank-
favor of the reconsideration on 910? Okay. It's
Thank
back-
you.
Back in committee. Thank you. Pardon me? All right. That ends our voting session for today. Thank you all. Have a good weekend.